It's a taboo conversation to have, said Yoram Rodriguez, 57, a deputy director of youth services living in the Bronx. He's talking about encouraging family members to make a will and estate plan. It's been a year since his beloved mother, Eunice, 76, passed away after suffering from stage 4 melanoma cancer. She bought their 4-bedroom family home in 1996. She did not have a will. With the bustle of all the time spent living, it becomes easy to turn away from difficult conversations about a relative's passing and the aftermath. This is particularly true for older Black and brown homeowners who are statistically less likely to have a will or trust prepared in the event of their death, possibly leaving loved ones without an opportunity to inherit wealth across generations. Nearly 70% of senior Black homeowners and 76% of senior Hispanic homeowners do not have a will or trust, compared to the same demographic of older white homeowners with children in the U.S., according to recent Urban Institute data. This could be for several personal reasons. Some people don't think they have enough assets or money to plan for, it's a cultural taboo to discuss, or some seniors and their families just aren't interested in accepting the inevitable, say legal experts. Estate planning is a crisis facing Black and brown homeowners in Bed-Stuy that is too often swept under the rug, and too many lose generational wealth simply because they lack access to clear information and affordable legal support, said Councilmember Chiasi in a statement. I would say the closer we got to realizing that it was terminal, we talked more about it. But by that time I don't know. I think my brother and I were just so caught up in just trying to take care of her on a day-to-day, said Rodriguez. When you don't have a will. In New York State, individuals and families go to Saget's court when someone dies. When a person dies without a will, or intestate, the families go to the administration department. This means that if the decedent had less than $50,000 in personal property, voluntary administration can be filed. If not, the distributes, or heirs who are entitled to a share of the deceased person's property, have to go through a costly and lengthy administration proceeding. At worst, people could lose family property to unpaid taxes, or unpaid mortgages, and potentially a shot at building generational wealth, said State Assemblywoman Latrice Walker. We must have a plan. Rodriguez and his brother currently have a letter of administration from the courts, which allows them to control their mother's estate and the eventual sale of her house. His father was technically still married to his mother at the time of her death, but they were separated and he waived his rights to a share without a fight. His brother, who lived in the home with their mother before she died, was surprised that his name wasn't on the deed. Luckily, his family are all on the same page and have opted not to be in conflict over the house in court. Legal experts lament that some of the worst infighting among families can be over real estate. His mother's hospice and general care was made easier by the fact that she was organized and a very good steward of her bills, said Rodriguez. He was added to her account to make payments on her mortgage, and her single credit card debt was forgiven upon her death. In the experience of Casey Lee, many homeowners in Black and brown neighborhoods are cash poor. More than 60% of older Black and Hispanic homeowners without wills don't have $500 in liquid wealth, which includes assets, checking accounts, savings accounts, money market funds, stocks, and stock mutual funds, according to the Urban Institute. This makes it harder for some homeowners to handle the costs to create a will. More often than not, the biggest barrier to will-making for Black and brown families is money and access to legal services to hire an attorney. There are financial predators all over, lying in wait to take people's homes, either through fraud, deception, tax lien sales, or other means. We can't allow our people to contribute to our own financial demise, said Walker. We have to keep Grandma's house in the family and out of the hands of greedy gentrifiers who will repurpose it and push people who look like us out of our neighborhoods. Rodriguez's father recommended him to a lawyer to deal with the administration proceedings and file their paperwork. He was charged about $3,500. Their letter from the court comes with a stipulation that requires another $2,000 to be lifted. That's in addition to keeping up with house payments and fees, or he risked losing his mom's house to foreclosure from the bank. It's difficult for the average person who's not litigious, and, if you don't have that kind of money just lying around, it's not advice about setting up a will, or call CNYCN's Homeowner Hub at 646-732-5101.